Okay, welcome everyone. Thanks for joining us today for our book event. We are joined today by Jennifer Aston and Amy Froide to hear more about Jennifer's book, Deserted Wives and Economic Divorce in 19th Century England and Wales for Wives Alone. I am just going to briefly introduce our guests today and then turn it over to them. They're going to have an informal conversation, and then we will have time for Q&A at the end. So do keep your questions ready. You can either feel free to drop them in the chat at any time, and we can turn to them once we get started, or once we open up the Q&A, feel free to raise your Zoom hand. So we are joined by Jennifer Aston, who is Associate Professor in Law at Northumbria University. She's the author of Deserted Wives and Economic Divorce in 19th Century England and Wales for Wives Alone, which we're going to be hearing about today, which was the winner of the SLS Margaret Brazier's second prize for Outstanding Mid-Career Scholarship, and was shortlisted for the Hart SLSA Book Prize and the Socio-Legal Theory and History Prize. She's also the author of Female Entrepreneurship in 19th Century England, Engagement in the Urban Economy, which came out with Palgrave in 2016. And she has served as production editor of Feminist Legal Studies, deputy editor of History, the Journal of the Historical Association, and is chair of the Publications Committee of the Economic History Society. So welcome, Jennifer. Thank you for joining us today. She's going to be in conversation with Amy Froide, who is professor of history at the University of Maryland, Baltimore County. She is the director of the Drescher Center for the Humanities at UMBC. And Froide is the author of Silent Partners, Women as Public Investors During Britain's Financial Revolution, 1690 to 1750, which came out with OUP in 2016, and Never Married, Single Women in Early Modern England, which came out with OUP in 2005. She has served as the book reviews editor for JBS and an executive council member for NACBS. So thank you, Amy, for joining us today, and I will turn it over to you to get started.
Thank you, Amanda. Thank you for those nice introductions. Hi, everybody. It is so nice to see so many friendly faces and names on the screen. Thanks for joining Jen and I today. And I want to say that today is the publication day for the paperback version of Jen's book, Deserted Wives and Economic Divorce. So I think, all right. So I think after this taster, you're going to want to run out and get that paperback. So to get us started, I would love Jen to talk about the process of how she created this book, which is somewhat unconventional. Jen was working with a co-author, but a co-author who had passed. And so it's kind of a posthumous collaboration in many ways. And so I thought it would be interesting to the audience, Jen, to hear a little bit about that before we then jump into the findings of the book.
Yeah, of course. Thanks, Amy. The book came about because it was meant to be an article. So I think this is probably something that's familiar to many people in the room. I was writing a grant application for a project on divorce and went back to read the actual kind of legislation itself and came across Section 21 of the Divorce and Matrimonial Causes Act and thought, oh, this is really interesting. And I'd actually researched, as part of my PhD, a woman who had a Section 21 order because she was a businesswoman in 19th century Leeds. So I had heard of them before, but I hadn't thought about them in the context of the divorce legislation. So when I went trying to find some academic literature on this, I really couldn't find an awful lot at all, but there were two articles written, one research note and one article by a woman called Olive Anderson. One in Past and Present, which was about kind of the making of civil society. And then the other was a research note in the Economic History Review, where she was talking about women whose husbands had deserted to go to the colonies. And part of it was a footnote actually in both articles that said, I'm working on this book. And I said, great, went to the library trying to find the book, and the book didn't exist. And when I was kind of Googling to see what happened, I found Olive's obituary. So she had actually died in 2015. So I didn't know Olive at all. This was in 2020 that I was kind of starting this research. So we never met. And in the obituary that was in the Guardian newspaper, her daughter Harriet had actually written it. And she said, that when her mother had died, she'd left behind the typescript for a manuscript, for a book that had been meant to be called For Wives Alone. And so I was a little bit creepy and emailed the Guardian and said, obit editor, and I said, listen, I know this is weird, but please could you pass on my details? And I was really lucky that they did, and also lucky that actually Harriet still had the same email address because it had been, quite a long period of time by that point. And so Harriet emailed me within a few days, and she said, "Oh yeah, and actually we kept it. When we'd cleared out the house, they'd kept this manuscript." So, and she, like, long story short, I ended up going down to London to have a look at the manuscript at Rachel's house, Harriet's sister, Olive's other daughter. So that was kind of where the process started. And actually, really what I wanted to look at the manuscript for was that Olive had been talking about statistics about women who had these protection orders. And that had been where I'd really been falling down with them, because I knew that my one woman in Leeds had an order. And I'd started doing some research using the online British newspaper archive, and had found like hundreds and thousands of these cases reported in the press, but I couldn't find any official statistics. And in Olive's article, she had spoken about these judicial statistics reports, and at that point, I didn't know what they were. So I was hoping that I could find out more about them in her manuscript. But when I actually went down to read it, there was a line in the manuscript that said, "When we know more about penny capitalism in Victorian Britain, we will know the full impact of these Section 21 orders." And I got goosebumps reading it, because that was what my PhD thesis was. And the manuscript Olive's manuscript had been written in the kind of mid 90s, and she'd kind of stopped working on it around about 1998. The last kind of work, I think, really had been done in about 2001 is the last evidence I can find that she did anything to the manuscript. And yeah, basically, I just thought how different my PhD, which I was doing from 2009, would have been had she published that book when it was meant to be published. And I kind of said to her daughters, what do you want to do with this? Do you want to do anything with it? And the way that it actually stood was that she had envisaged a book in 3 parts, which our book kind of rough-ish follows. We have 3 parts. They're not in the same order that Olive had envisaged. But she had written the first bit and edited it really quite, it was ready to go, really. It was as it stood then. It needed updating in terms of historiography and new research techniques and things, but by and large, it was well written and quite complete. The second part had been drafted, but was nowhere near kind of edited. And the third part had been sketched out, but then actually it turned out had been kind of cannibalized by other parts. So that bit wasn't existing. So in essence, about half the book was kind of there. And I said to him, what do you want to do? And they said, well, it would be lovely if it could be finished, but we didn't know anyone who could do it, and they weren't in a position to do it themselves. And I said, well, if you don't mind the fact that it would be a joint thing, then I will do it, because I felt like there was the information about Section 21, but there was also something more important there as well, about the fact that this manuscript had laid kind of for almost 20 years without anyone actually kind of taking on the topic somewhere else, even in isolation from Olive's work. Nobody had looked at it, and I don't think that we'd really, as a kind of field, had appreciated the impact of that legislation. So it was kind of ended up being a bit of a dual project.
I just love how you describe this in the book. And it's kind of haunting, that idea, or haunting for an academic, the idea of all the unpublished writing, right, that we maybe have in our drawers. And then a really hopeful story of how you were able to take that and work with Olive and create this collaborative book. And you talk very, very intentionally about the parts that are maybe more in your voice, and the parts that are Olive's voice. But I have to say, it comes together very seamlessly. It does not seem like, that you're find yourself going between 2 different voices too often. So it's a wonderful story. So tell us about Section 21 of the Divorce and Matrimonial Causes Act, and why you wanted to write this book about it. What inspired you?
So I think first off, I kind of need to admit that it was my academic shortcomings that really got me started on this project, because, like I say, I'd found a woman in Leeds who had a protection order, and actually she was the first woman in Leeds to get one of these orders. And the magistrates had, when they had issued it, the newspaper actually reported that they had said, we understand that this is the first of many applications many applicants basically who are lined up ready to apply for one of these orders. and it was incredibly important for this woman's life, and I'd written about it and said how important it was for her life, but I hadn't thought about the other women that came after her. I'd been focused on her in the context of 19th century lead kind of business economy. I hadn't been thinking about her as one of many women who were doing similar things. So when I kind of came back to the legislation and was thinking about this research grant application and what I could do while I was waiting for it to go through peer review, and thought, actually, like, I'm going to go back to that and I'm going to look at it in more detail. And so for those of you who don't know, Section 21, and I admit that, one section of a piece of legislation does not sound like the most exciting topic for a book. But actually this, it was really cool. So Section 21 was a section of the Divorce and Matrimonial Causes Act, and it allowed married women who had been deserted by their husbands and who were economically self-supporting to go to either the Central Divorce Court, or they could go to their local magistrates court if they were kind of in the provinces. If they lived in the kind of metropolitan area of London, they could go to a police court. And they were able to apply for the equivalent cost of about £30 today. So I don't know, would that be about $60-ish in the US? They could apply for a Section 21 order, which immediately revoked kind of all the restrictions of coverture. It reverted them to being a femme sole in every single way, apart from the ability to remarry. And I have to admit that the way a lot of these women talk, like remarriage is the last thing in their mind. They are not interested in another husband when they've dealt with the one that they've got. So why I think it's important is kind of threefold. So first is what it does. So it does this incredibly radical thing where it actually just removes all the restrictions. When we see pieces of legislation that are maybe more well known in terms of women's kind of developing legal rights in the 19th century, like the Married Women's Property Acts, they actually don't do this. They don't remove restrictions. What they do instead is change the relationship of women and property. They don't just give the woman the legal autonomy to be a femme sole. So it is the only piece of legislation that does this. The second thing I think is really radical about it is like how they did it. So it's the only bit of the Matrimonial Causes Act of 1857 that is enacted through a local magistrates court. All of the other provisions have to be done via the Central Divorce Court in London, which, if you think about the logistics of that, even for a relatively small country like England and Wales, which is the jurisdiction we're talking about, it still made it very, very difficult for people to access, especially women, married women, to access those provisions. So the fact that you could go to a local magistrates court and apply for such a small amount of, with such a small fee to be able to get one, I think is kind of the second really radical thing about the legislation. And I think the third thing that makes it really interesting is how many women used it. So if we look at the Matrimonial Causes Act as a kind of a whole, the Section 21 orders kind of taken as a combined from magistrates, police courts and the Central Divorce Court, they account for about 99% of the court's business. So out of all of the divorces, all of the judicial separations, everything that's going on, Section 21 is really what is the bread and butter of this, of this piece of legislation. But what's really interesting about it, again, is that, like 95% of that is not happening in the divorce court. It's happening in magistrates courts and police courts. So there are more, I think conservatively, there are more than 20,000 women who have a protection order in the period that this book's looking at, so between 1858 and 1914. And they do trail off dramatically after 1882 with the Second Married Women's Property Act. But you see this huge number of women who are actually accessing a provision that were previously totally invisible. So yeah, that's why I think it's so important, and I think it really changes the way that we kind of can imagine women and the law in that period.
It's truly an amazing discovery, Jen. And this gets to my next question. And you probably laughed when when you saw this. I mean, why have historians forgotten about Section 21? Why have we neglected it if it's as revolutionary as you say? And you gave us a little hint there about jurisdiction, right? And about legal jurisdiction.
Yeah, so I mean, this will surprise nobody who's worked with British legal records, but they are the storage of them, shall we say, or the retention of them is somewhat patchy. I'm trying to think of a nice way to phrase it. And basically, magistrates' records were destroyed. And I was talking actually to somebody right at the beginning of this project at the who works in the Ministry of Justice, and I was kind of saying, I just don't understand why all the magistrates' records aren't here, like at the National Archive where we were at the time. And she kind of looked at me like I was stupid, which I was in hindsight. But she said, well, of course, magistrates' records aren't held at the National Archives. They're held in their local archives. But so many local archives destroyed the records that they had because they had done the reporting to the higher up kind of bodies and then got rid of the paperwork. So what we actually have in terms of records is really sparse. Because the Central Divorce Court kept divorce records and judicial separation records and things that were heard in London, we're really lucky in that about 187 of the cases for Section 21 applications were caught up in those records. So we can see some cases that were retained in that way. But there are very, very few applications that survive made to the magistrates' courts. So what we actually have are the judicial annual judicial reports that were, again, as the name suggests, were reported annually. And so, but what we have there are the numbers that are reported by circuit. So a kind of small groups of magistrates' courts report back and say how many orders they granted. What they don't tell us is how many orders they received. So we kind of have half, maybe more than half a picture, but we have a kind of rough picture of what's happening in the provinces. And we have newspaper records. And that's really where the kind of the rich detail of these cases comes from, is because we can see from the local newspapers, especially because they're so interested in what's happening, in a kind of a gossipy way in the magistrates' courts. So they're saying, Jane Smith came before the magistrates' courts on such and such a day, and she applied for a Section 21 order, and she did so on the grounds of, and then they explain why. And so sometimes we see that they've been rejected, and sometimes we see that they've been granted, or sometimes they get sent away for extra material. So that's kind of one of the reasons, actually, is that these records are really difficult to find. They're not obvious, and they don't exist in one neat place where you might have, you might discover them and think, oh, I can write something quite substantial about this. I think the kind of second issue is to do with the way that historians have looked at the records as well. And I include myself in that. Like I've said to you already, that I kind of had not considered my woman in 19th century Leeds as being representative of a bigger sample. So that was my oversight, completely in that. But there have been records that have been misinterpreted as well. So Lee Holcomb kind of described Section 21 as being, more or less completely ineffectual, and that it didn't work. And then because that book is so important in the historiography of women's work, it's been taken as kind of as truth and repeated. And so people haven't gone looking. It's not that not that the records aren't there, it's that people haven't then looked because that's been the picture that's been painted. But actually, in defense of historians who have looked at these records, there are also a number of records that have been made by men at the time who did not understand the legislation they were talking about. And so they've actually made misleading statements themselves, which if you read the archive in the wrong order, or you happen upon that record first, then you would think, oh, well, no, they're not important because this important, politician has said that nobody uses Section 21 order, so why is it even on the statute books? When actually the truth was totally different. He just had no understanding of what he was talking about. So we have this really kind of multi-layered, it's almost like a perfect storm of invisibility for women, which also isn't helped by state invisibility as well. So because the women weren't divorced, they're still married. So if you look on official census records, the women still record themselves as married. In fact, there isn't even an option to be divorced until 1921. So there really isn't a legal category for them. So in all of those records where you might have been able to say, well, this is weird, we've got a subset of women here who say they're deserted or separated or something, you don't have them. Most of them are recorded as married, with the odd kind of renegade who's deliberately just, put something different down that they shouldn't have done really on the census return. So it really is a say a perfect storm of becoming hidden, I think, rather than being hidden at the time.
I like that distinction, becoming hidden versus being hidden. And now you had to unwrap, historiography, contemporary lawyers' misconceptions, questions about where these records would be. And then, oh, the records actually don't have much in them. And then you had to think about where can I get that information? And it's newspapers. Before we get to the newspapers, though, I want to point out you did not title your book Section 29. In fact, you instead give us more of an argumentative title, and you talk about what you refer to as economic divorce. So, can you talk about that decision of not referring to Section 21 orders all the time and instead having your reader think about economic divorce?
Yeah, so it was a contentious issue, and it was one that I thought about really carefully. Partly because it was something that I inherited. So Olive was the person who had coined the term economic divorce. And when it came to like reviewing the manuscript and thinking about what bits would stay and what bits would go and what bits might be altered and how things would be added to, this was definitely a conversation that I had actually out loud quite frequently. I do talk about in the book how I would be reading this manuscript, and actually it's probably worth explaining really briefly if I can what the manuscript was like, because I basically came home from London petrified on the train because I was carrying these 3 ring binders that were full of paper that in some cases had actually been typed on. It was a proper typescript, not others had been printed. There was no electronic copy, so I had the only copy. And then it was a kind of decision about how we then created an electronic copy and something that could be edited and worked with. But all of the kind of records had tiny pencil annotations on them where she'd kind of gone back to things and rethought about things, and they were all printed on the back of other documents. So actually I could have written a whole other book about the stuff that was on the back of her typescript. But yeah, when I was sort of then, so I decided actually that I didn't want to outsource the typing. I didn't want to give the manuscript to anybody else. I didn't want to put it through a photocopier and potentially mangle it and then have destroyed the only copy. So I basically sat and typed it. That was my first stage. And in doing that, actually, it became a conversation. It became kind of a communion in a way of figuring out what was meant and what was intentional and how I worked in the edits that had been made. And I actually used to sometimes say, what do you mean here, Olive? Like, what is going on? What was this? But then by the next page, it would all have made sense. And I'd be like, oh, okay. And so I'd go back and figure something else out. So the economic divorce was one of these out loud conversations that went on for quite a while. But I think that there were a few reasons why I stuck with it. And I actually think it was the right decision. So now I feel like it's my decision as well. But the first was that actually, although Olive kind of coined the phrase, and that was what she was sticking with, she borrowed it from the newspaper accounts themselves. So this is a phrase that was understood at the time as as something that was kind of identifiable for what the applications were. The second thing is actually, I think it's really accurate, because it does describe exactly what happens to these women. As soon as their order is granted and they've registered their certificate with the registrar, they are economically divorced. They're literally, their relationship with their husband, although they're still married, is that of a stranger. If they drop dead, down dead on the street, their children or their next of kin will inherit. The husband is no longer their next of kin. So there really is a total separation. And equally, she can't now call on him for any help either. She is independent. By going through that process, she's given up the rights of coverture, the right of protection under that system. And she's got to sink or swim. And I think significantly, actually, for the majority of the women in the sample that we looked at, they have children too, and they become economically responsible for their children. So it's a really big step. And I think that economic divorce actually recognizes that level of legal status in a way that protection order doesn't. But then the final reason is also, a lot of people are really familiar with the term protection order in the context of the 1878 Matrimonial Causes Act, so physical protection. And I really wanted to differentiate from that, because there is nothing within the Section 21 that accounts for physical mistreatment at all. So women have still got to wait another kind of 20 years for that to kick in, but they are different orders. They're different sections under the legislation, and so I think it was really important not to confuse those two legal provisions, and so economic divorce kind of kept that distinction quite clear in my head, at least.
No, and I think it really helps the reader too in a lot of ways. But I think that by calling it economic divorce, it really forces us to think about what kind of separation has occurred here. You're right, and I think it's really important you talk about the both giving up the disabilities of coverture and also the positives of coverture in some ways through a Section 21 order. Let's talk about some of the women who ask for these orders, who apply for these orders. Class is an issue, region is an issue. I think this is a wonderful book in explaining how London is different from other regions, and what the occupational structure of the districts where women are applying for these orders.
Yes, there are some really great maps in the book, actually, that, like, I'm saying they're great because I didn't produce them. I said to some really kind of techie smart people who can do things that I can't. I was like, I know the data is showing something here, and I think it would be really cool if we could visualize it. And actually, what happened was when the kind of the data was shown up, we were able to see that there's a really clear correlation between industrial. So in the provinces, there's a really clear link between industrialization and these orders, but very specific types of industrialization. So the northeast of England, which has a lot of heavy industry, which explicitly excludes women after the 1840s, after Factory Acts and Mining Acts and things like that, there are very, very few protection orders. So this is where actually where my university is based, and I was doing a local radio show, and I was trying to find somebody who had applied and couldn't. I was like desperately looking through for anyone from the northeast. Very, very few of those orders are registered there, because there just wasn't the facility for women to be able to be economically self-sufficient. So what you see instead in the newspapers are lots of women saying, we want our husbands to support us, and suing for maintenance, and for the husbands to come back to the house and to provide for them. So you see a differentiation there. But in Manchester, the kind of regions surrounding Blackburn, kind of that whole kind of cotton industry, even into West Yorkshire, to Leeds, so the highest proportion of women actually applying for these orders are in Leeds, which makes my oversight in the first place even more embarrassing. But you see it's really heavy concentration of women there, and then stretching down through the Midlands with the small metal industries and the potteries as well, slightly further north, and then down into London. You see really heavy concentrations there, and it's because women, especially in the northwest with the textile factories, were able to command a living wage, so they could survive when their husbands left them, rather than being in a situation of destitution. But we did see really kind of quite stark differences in the types of income that the women are reporting. So particularly between the Metropolitan Police Courts in London and the women kind of in the northwest. So the book actually takes like the area surrounding Blackburn and then London as its two kind of comparison districts. And the women in London were largely in receipt of passive income. So they were going to the court because they had a trust or they had an inheritance due, and they didn't want a husband who had maybe deserted years before to come back and take it. There weren't that many of them who were claiming economic independence through employment. Whereas the women in the northwest they had earnings, they had saved, and one of the kind of patterns that we saw really kind of echoes what men were doing in that period as well, which is they're working in a factory job, they're saving up, and then they're opening a shop. That was kind of the kind of petty bourgeoisie, dream of kind of making it. And so a lot of these women are at the stage where they're ready to open a shop, but they're also not so stupid to open it before they can ensure that a husband's not going to reappear from the woodwork and take everything. So we see these really kind of distinct differences, and we also see distinct differences in the way that the women are treated in the courts as well, primarily because the courts are actually very different. So although the price was the same and the process was the same, if you were a woman applying in outside of the metropolitan area, then you would sit before a bench of maybe 3 magistrates, and they would be drawn from the local kind of great and good. So they'd be in the Northwest, they were drawn from landowners, they were, kind of the gentry, they were factory owners, they were mill owners, and they all have a vested interest in keeping their local society in balance. Whereas in London, if you go to a metropolitan police court, you're facing a legally trained judge who is on the first rung of that kind of greasy ladder of judicial progress, and they're paid a lot. Whereas the men who are on the benches in the provincial courts are not. They're deliberately lay magistrates, so they're volunteers, and then also can't be legally trained. So you have a very different reception to these women as well. So we see women in the Northwest walking in and saying, "I would like to apply for it," and they say, have a Section 21. You go and enjoy it. Whereas you see women walking into the police courts in London, and actually some of the records, the newspaper reports are awful, because they walk in and they say, "I've been deserted, I've been supporting my children. And my husband threatened me with a gun once." And they say, "Oh, well, that's cruelty, so you need to go down the road to the divorce court." But what that means is actually, like, instead of 30 shillings to get your 6 shillings to get your Section 21 order, you've then got to pay a minimum of £50 to be able to get your divorce. So it really kind of cripples a lot of the women who are trying to apply for protection and economic divorce in the London courts. So we see kind of a difference both in the types of women who are applying, and then also the way that they're treated when they get there.
I think one thing I was surprised by as I was reading is frankly how successful Section 21 was, how much it helped certain women. Kind of shocked that Victorian society would enable, right, the independence of certain women. And then I was really persuaded by your argument that actually, if you think about it, Section 21 really fits Victorian values. And so it's not a total surprise that actually it was something that magistrates and lawyers would ultimately feel comfortable applying. Do you want to talk about that for a second before we open things up more broadly?
So I think you're right. It absolutely upholds Victorian values in terms of it protects a unit, so it protects the responsible adult and any children. It maintains the marriage because it doesn't allow for a divorce. So it's almost like pretending that the marriage is still happening, but and it's keeping people from I suppose kind of informally breaking down. They're not taking matters into their own hands. It's still a state sanctioned response to a problem that has been, time immemorial, men have disappeared. So so I think it upholds it in that way. I also think in a slightly cynical way, it solves a lot of problems for the state as well, because it removes the expectation that the state will provide for this woman and potentially any children. By going through the order, she said, "I'm on my own." And so at that point they say, "Well, this is your problem now, deal with it." So yeah, if you're being a bit cynical, then I think you can see it in kind of two ways. But in terms of actually how it comes to be in the Divorce Act, because it is totally weird when you read it against all the other provisions in that piece of legislation, I think it really kind of points to the slight random nature of how the sausage is made when legislators are kind of in the House and discussing things. And this was actually some of my favorite bits in the manuscript that I inherited from Olive was she had found these amazing newspaper, her research was incredible when I think that the actual practicalities of what she was doing and the way she was working. But she had cross-referenced newspaper reports and weather reports from the from when the debate was going on in Parliament, and then also looked at lots of private letters of the men who were involved in shaping this legislation. And essentially, some of them were called to an audience with Queen Victoria, so had to leave early to get the train down to Osborne House because she was on the Isle of Wight at the time. There was a big heat wave, and Lambeth Palace had notoriously bad sewers. So across from the House of Commons, it stank. Nobody wanted to be in the chamber because it literally stank of sewage, and so they all wanted to go home early. So when this kind of radical piece of amendment was issued, by that point they were kind of throwing their hands up and saying, you know what, we just want to go home. And so it sneaks into the final act that's passed. So there are kind of lots of sliding doors moments, I think, in the story, not just of how the book came to be, but how the legislation came to be as well.
So women are ultimately benefited by the weather. Yeah. Not intentionally. It seems like a great place to pause and open things up to the audience.
Sure, absolutely. So we are going to open it up for Q&A. As I said before, you can either pop your question in the chat and I'll read it out for the recording, or if you want, just go ahead and raise your Zoom hand, the little emoji hand.
Amanda, do we have an emoji hand? I'm not seeing it.
If you go to the heart react, usually,
Yeah.
it's in there.
Oh, there it is. Sorry.
No, you're all right. Sure, Susie, go ahead.
Instant gratification. Thanks, Amanda. Amy and Jennifer, thank you so much. Jennifer, thank you for writing this book. I'm so excited. I'm embarrassed to say that your 2022 article is still in my folder marked to read someday. I know we all have those folders, so I hope it's okay. So a bunch of things that you said are so interesting, and I think reflect so meaningfully on the historiography. Olive Anderson felt to me like a sort of giant from the past when I started reading in the 90s. So I'm so thrilled to see her work come back here. I just I had a suggestion about this sort of I had a thought about why didn't this get why did this get historicized the way it did that Amy was asking you about? And one is that, and it sounds so dumb, but I think sometimes as historians, we really take like the top line from the executive summary and we don't follow it up. So for instance, I'm thinking about the Married Women's Property Acts. There was a whole generation or two of historiography that was like, well, 1870, that was the big one. And then later we cleaned it up with 1882, whatever, who cares, right? When in fact, 1882 really made the act so much more meaningful and changed so many people's. And I think similarly with divorce, we were like, well, the headline is divorce. There's something about separation, whatever, who cares, right? Sort of not reading below. So I think I think you've pointed to a much bigger problem in how we read things and how we think about things. I'm also really interested in the relationship between economic separation and married women's property around wages, right? Because as you point out, like women who are seeking to protect their wages are very different from women who are seeking to protect some kind of passive income. That's very, very different. And there you see like a sort of a north-south or a London everywhere else split. Whereas the Married Women's Property Act, it's a bit flipped, isn't it? Where 1870 only protects wages, if I'm remembering correctly. And then everyone says, well, that's great, but most women don't have wages. Well, not most women. Lots of women don't have wages, but do want their own property. So there's a bit of a flip there. So I guess I'm just interested in anything more you have, if you have more to go deeper, and you might not, you've already said a lot about the historiographical issue and about the sort of waged versus non-waged women issue.
Oh, thank you so much. And yeah, I could talk about this all day, so I've got loads more. But yeah, I think the Married Women's Property Acts, as a sign of what you were just saying in terms of the way the historiography has developed, is absolutely bang on, because this is something that I try and tell my students all the time, is that the Married Women's Property Acts, that I actually really hate the 1870 one. It really, really annoys me because of the way it's lauded and celebrated, and there's very rarely any recognition that actually, quoting Spider-Man here, with great power comes responsibility. So the women can claim their earnings But nobody ever talks about the fact that if they did claim their earnings, they became responsible for their children. And this is a huge get out of jail clause, free clause for men to say, well, crack on and take your money, but you can take the kids as well. This is not it's not the granting of a right. It's not the granting of a privilege. It's a double-edged sword.
And that get out of jail free card around children and custody very much applies to divorce as well, right?
Yes, yeah, absolutely. And so I think that, women, so under the 1870 Act, they can inherit up to £200 as well. So that the inheritance is also something that plays in heavily to the Section 21 applications. There are a lot of women who actually the executors of the wills won't release the money until there's a Section 21 order in place. And we had there's some really great examples in the book where women have, in fact, there's sort of two women who are found in the records who are distantly related. I don't think they knew each other, but they both end up in Section 21 with Section 21 applications in the divorce court at the same time, because it's kind of like a fairy tale. A great 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 uncle has died, and basically he had written this really complicated will that had all sorts of male heirs listed, and the male heirs didn't outlive his wife, who lived for a long time after he died. And so eventually these two very ordinary women who have both had absolutely useless and actually in some cases, really cruel husbands end up inheriting. But they go through a very complicated probate process, and the Section 21 order has to be in place before any of that estate will be released. So they can be, it can be quite a convoluted process in terms of navigating property and wages and inheritance. And I think actually the idea of posthumous control over the estate is where women really saw the value in Section 21. And it's why when there are graphs in the book that just show it literally drops like a stone. The number of applications just falls off a cliff edge after 1882. There's a tiny dip after 1870, where I think women thought, oh, we don't need this. And they go, oh, hang on a minute, this act is useless. It's doing nothing for us. We do need this. It does something very different. So they apply for they start applying again, and there's an upsurge. But after 1882, when they're able to retain control and make a will, then that kind of drops off. But I think, the willingness actually of, if you think about how the field came around, about of women's history, that, the first historians were activists before they were historians, and they're looking for reasons for why the situation in the 60s and 70s was the way that it was. So it makes sense that you go looking for what you're trying to find. And I think that what we're kind of unraveling now is the aftermath of not being afraid to say things were messy, that there is space. I think maybe this is over optimistic, but I think now there is some space for things not being perfect and women not being perfect, and allowing that.
That's a great point. And now I'm wishing that Bleak House had been written just 7 or 10 years later, and then Dickens could have put Section 21 into the whole thing, and then all the Dickens world people would have been obsessed, and we would have known much earlier. Thank you.
Thank you.
Thanks, Susie. Courtney, you want to go ahead? We'll do Courtney, and then I'll pull some questions from the chat.
Yeah, thank you so much. This has been really fascinating. I would love to know more about sort of what kinds of proof magistrates required in order to grant this decision. Because I know in Scotland you could divorce on the grounds of desertion, but they required like incredibly extensive proof, right? You had to like write to newspapers in the colonies and put out ads to be like, have you seen this man? And I'm wondering if that was the same in England and Wales, or if the level of proof was lower because it wasn't actually a divorce.
So what I nerdily think of is, this is really exciting bit of Section 21, because desertion under the Divorce Act had a totally different definition to desertion under Section 21. So if you were trying to get a judicial separation or an actual divorce, then you had to prove desertion over 2 years. And like you say, it's quite a difficult process in terms of, if a husband came back for one night that was him back, and the clock reset. So you could potentially be in this perpetual period of trying to prove desertion, and he just kept coming back and kept coming back, and so you would be, really stuck. Desertion under Section 21 does not have that definition. There is no minimum term. There is no requirement to prove anything other than you genuinely don't believe he's coming back. So your husband could leave the house one day, and you could go the next day to the magistrate court. And as long as you could persuade that magistrate that you believed he was not going to return, then you're entitled to an order. And actually, not that many of them require a huge amount of evidence. They seem to take the women at their word. But I think, again, this is my cynical explanation for this, is that it means that there is a chain of responsibility. They're not going to have to be the ones that are trying to find a husband who's gone walkies somewhere to make him pay for his family. If she has a protection order, then she's responsible. So actually it makes their life administratively easier to issue the order. So it is really interesting, though, when you see what the questions that the magistrates are asking, and sometimes it's really obvious. They'll say, I don't know, Joe Bloggs from the pub saw him with a ticket to Australia on Friday night, and he's now gone, and he's taken all his clothes with him. But they quite often will talk in terms of, like, he's taken his assets or he's stolen mine, and and I don't expect to see him again. But yeah, it's a much more rapid process, which I think in some part goes some way to explain why they're so popular.
Thanks, Courtney. So we got a couple questions for the chat. Some of them are related, so I'll just read them together. So from Brian, we have, "This is fascinating. Thank you. Could you say something more about which legislators were pushing this and why?" And then Sylvia says, building on Brian's question, "I wonder what kind of perception of women the writers of the legislation had."
So the real mix of people who are pushing for the legislation in Parliament, and they're not always the kind of factions that you think would necessarily be in favour. And I think that this is it's reflective of the fact that, like, the perceived woman problem goes across political divides. So for some people, the idea of actually retaining the marriage, because of course the wider debate going on at this point is the Divorce Act and how that's going to look and who's going to be entitled to divorce. So for a lot of conservative legislators and the church as well, this Section 21 order is actually the kind of preferable option, because, like I said, it kind of minimizes the impact on the idea of marriage as a kind of sacred bond that can't be broken. But what you do find as well is that factions change. So people are kind of are shifting as one amendment is moved and one agreement about, I don't know, for example, the minimum term of desertion, which at one point was 5 years. Then there shouldn't have been any period. Then somebody else was saying, well, there shouldn't be any minimum period for desertion. Should desertion be a sole ground for divorce, as it was in Scotland? There are shifting loyalties and things kind of maneuver. But to kind of build on from that as well, the perception of the women who were applying for this was very much considered in the same terms as the 1870 Married Women's Property Act, in that they're the poor women. This is meant to be a provision that is put in place for the working classes, for the women who were hardworking and industrious and had alcoholic husbands who were feckless or were leaving them in vulnerable positions. So it's very much seen as a way of protecting women. There's a really strong kind of paternalistic narrative around the women who are involved in it, and that kind of it does bleed into the way that the magistrates enact this legislation as well. So we had a case in Blackburn that particularly kind of pops into my head, which where a woman who had been running her own business and been deserted by her husband applied for a protection order, and he actually gets it overturned because it turns out the business that she's been running is a brothel. And the magistrates decide that even though, she technically on paper she is doing all the things that she was meant to be doing, because her income is from an immoral source, then she's not entitled to that protection, which has no grounds in the legislation at all. But it reflects the kind of moral judgments that were so kind of intrinsic to the wider period.
Thanks. We got another question from Jessica, who asks, was the language used in the newspaper rather sensational or just matter of fact?
It's actually really boringly matter of fact, apart from the headlines, which quite often are in capital letters and say divorcing magistrates. And there's this like mass confusion about whether people are or are not divorced. And the magistrates quite often are whinging in the columns saying, we can't give divorces. This is not divorce. This is a Section 21 order. This is protection. This is not, a full divorce. But yet the actual language used becomes, unless there's something really extraordinary in the case, it's very formulaic. Like say Jane Smith appeared before such and such bench and applied with an application for an order of protection or a Section 21 order. The terminology changes between publications and between reports. Her husband, Joe Bloggs, left on such and such a date. He's believed to be in Australia. She is deriving her income from X source. And that's more or less it. They're very, very short. And I think actually, kind of with my kind of business and economic history hat on from previous work, I think actually what they're really interested in is kind of protecting the local credit market, sort of credit networks. And they're saying, so-and-so is good for trade because she has one of these orders. So actually you can take her to court and you can sue her and she can be liable for debts and she can sign contracts and she can do all of these things. There's a way, it's more or less, I think, reporting so that everybody in that community understands what's happening. Because obviously a married woman's legal status changes what she can do quite dramatically.
Thank you. So that's all for the chat. Does anyone have any other questions? Sure, Susie, go ahead.
Sorry, I was wondering if you know of Vicky Holmes's book, Living with Lodgers?
Yes. Yeah,
I just thought, oh, go ahead, sorry.
Oh, no, it's, I can see Christina on the chat, who's is a postdoc still working with me, and we had been discussing this book, yeah.
Oh, I just thought it was interesting because you're both taking sort of pretty you're both getting to a legal thing via a newspaper report that is not particularly forthcoming. Yeah. So they're really similar detective works.
And I think that's it actually in the detective work, and actually thinking about what you said about Olive being, kind of a giant, in that when you look at her, kind of the work that she's done, it's so broad. Like there's just this wild range of stuff, like topics that she's targeted. She's gone from like the Crimean War to lay preachers to to Section 21 and kind of a whole host of things in between. And I think that was like she followed her nose and she found something interesting and kind of kept picking away at whatever it was and kind of gradually managed to unravel. And I think some of what is so interesting about the Section 21 cases, in contrast to the divorce cases, which I have spent like the last 2 years now looking at, is the totally unsensational way that they are reported. It's so, in fact, they don't, the newspapers that cover the divorce cases in the Central Divorce Court and most judicial separations don't even bother to report Section 21 applications that are happening in the same court, even though they're happening at the same time and the journalists will already be sat there. They don't bother. They're just not interesting to them, which to me makes it more interesting. Like, why are they not interested? Is it because they're so normal and so much of a kind of, ingrained part of the landscape by that point that they're not even worth sort of looking at. But even though, a lot of the details, when you read the few applications that remain that we can see in the Central Divorce Court, and we presume that they're going to be broadly indicative of the things that are happening in the provinces, like the details are just as scandalous as the divorce court files. But for some reason, that just doesn't filter through into the way that the papers report them.
But Jen, it's because, like you say, it doesn't matter if there was adultery or if there was, abuse, right, in those cases. So nobody's interested in just the economic details of the of a breakup, right? They want the salacious stuff.
I mean, that's actually a paper that I'm working on at the moment, and hopefully it should be finished very soon. But it's more of a contemporary case. But what I was really struck by when I kind of was looking at this kind of whole the data set as a whole is that even though the women only had to prove self-sufficiency and desertion, all of the applications that I can find in the divorce court, nearly all of them have other forms of so I'm counting economic abuse as actually the act of desertion, because I think that if you are a husband who leaves his wife on her own in this period, you know that she's legally hamstrung, right? So I'm taking that as kind of a baseline of abuse, but they nearly all have some other form of abuse, whether it's what we would now recognize as like sexual abuse, financial abuse, coercive control, all of these kind of things, physical abuse obviously as well. They're all in there, and they use their affidavits to say, this is what happened to me. And this is not in any expectation that anything else is going to happen. Like, they're just applying for their Section 21 and they know that that's all they're going to get. But they have the opportunity and they take it to have a platform to say that this might not be legally wrong, but it's morally wrong. And I don't know, to have their moment to record what happened to them. And it's really powerful actually when you read their stories.
Jessica, go ahead.
So I was thinking about this in two different ways. One is the taking of testimony from women, and I just finished some work on Josephine Butler and the Contagious Diseases Act and all of her questions that she asked women and put them into her records in order to get the legislation revoked. And the second thing is I just need a little clarification on the custody of children and when actually a mother has full custody of her children, as opposed to the husband having custody of children. And this may or may not be pertinent, but it's of concern to me. So I'm going to ask the experts.
Oh,
Thank you.
I would love to read your stuff on Josephine Butler. I really, really enjoy her work. But so the way that the testimony is taken, as far as I can tell, is they give oral testimony to the magistrates. But we know that they also write an application. So there's a really simple pro forma that's issued, and all the clerks have a copy or copies, and it's filled in, and it literally has spaces. So it says that, A, married, B, on C date, and you fill in the form. And then there's the records from I don't have any evidence of this happening in the provincial courts because we don't have the records, but the records from the divorce court suggest that they also then put an affidavit with that pro forma that basically outlines their relationship from their marriage through to the desertion, or like the present day, probably to kind of stave off any questions about, oh, well, maybe he's not actually deserted, or are you actually earning your own money? And so to establish those facts. But like I say, they include lots of other detail in there as well, which is really helpful actually if you're kind of trying to reconstruct these lives, because it includes things about where the children are born and when they're born and houses they've lived in and things like that. But yeah, speaking of children, then in terms of custody, as soon as that order is granted, the wife is fully responsible and has full custody, so that the husband no longer has any paternal rights over the child. Because if you kind of follow it through legally, she's reverted to a femme sole, and unmarried mothers are responsible for their children. So it's as if she's had them out of wedlock. They don't become bastard children. They're still legitimate children, but legally, it's as if they weren't part of that relationship. So in some ways, it doesn't mean an awful lot, in that I have a case where a husband went out for a walk with their eldest child and just didn't come home. They moved to the continent, and so he took the eldest child away, and she really didn't have any recourse after that. But in theory, at least, it means that the women can make decisions about their children.
All right, thanks, Jessica, for the question, and thank you so much, Jennifer. So we are up on time now. I want to thank Amy so much for being our moderator and comment today, and I want to also thank Jen for sharing all this amazing research with us and about the project. Um, we have a couple of events left before we take a little summer break, but we are also looking ahead to our fall schedule. So I would say for any NACBS members that have books coming out, or maybe know someone who has a book coming out, I would encourage you to, or encourage you, or encourage you to encourage them to get in touch with me and figure out a way to schedule something for them. So I hope everyone will join me in thanking Jen and Amy, and we'll wrap it up for today.
Thank you so much. Thank you.
Thanks, Jen. Thanks, Amanda.
Thank you for having me.